Article 2 of the Convention is in many ways one of the most difficult. It's also one of the most important because it can trip up arbitration awards and arbitration agreements that are perfectly inoffensive. So it's important to get control over it. Over the years, there have been huge arguments about the meaning of an arbitration agreement subject to Article 2, particularly the meaning of an agreement in writing that we're going to find in Article 2.2. Strangely, developments in modern technology make Article 2.2 less of a problem than it was, say, 20 years ago. Nevertheless, we need to have some control over Article 2, partly because when the New York Convention gets to be redrafted, and one day it will be, this will be the article everyone's going to spend most of their time with. Which is slightly ironic because if you look at the Travaux Preparatoires of the Convention, you'll discover there was virtually no discussion of Article 2 at all. It was slammed in at the last minute. And what we actually have in Article 2 is relatively similar to the Geneva Protocol with one exception. And that is the reference to an agreement in writing, which you won't find in the Geneva Protocol of 1923. So what's it all about and what's the problem? Article 2 is all about enforcing arbitration agreements, sending parties who go to court off to arbitration when the litigation would be in breach of the arbitration agreement. That's the idea. That was the idea behind the Geneva Protocol. Where does this requirement of in writing come from? It appears in Article 2.1. It doesn't appear in the Geneva Protocol. Nobody really knows. There are lots of discussions about the origins of any formal requirements in arbitration. They probably stem from the fact that if you agree to arbitrate, you give up your constitutional right under a number of European countries to go to court. In modern times, an agreement to arbitrate will get rid of your rights to, under Article 6 of the European Convention on Human Rights, to a fair trial. And so one can say that some sort of ceremony or formality is required. The problem with this requirement of a writing is that it has a funny habit of catching all the wrong agreements. Where parties have freely negotiated an agreement to arbitrate, perhaps contained in a contract, but haven't gone through the necessary formalities under Article 2.2, you can get the slightly absurd situation where a party sues on a contract and then says, you can't send me off to arbitration because the arbitration clause in my contract is not formally valid, which makes absolutely no sense whatsoever. So with that in mind, attention really needs to turn to Article 2.2. And here there's a language problem. The English version says the term agreement in writing shall include an arbitral clause in a contract or an arbitration agreement signed by the parties or contained in an exchange of letters or telegrams. The French version doesn't say that at all. It says on entend par une convention écrite. So we mean by an agreement in writing, and then the following definition. The English version seems to suggest that a convention can go wider than the Article 2.2 definition. The French version, which is also the Spanish version, does not. What are we going to do about it? Well, actually, the problem is simpler than it looks. And it all comes back to understanding what the convention is actually about. Why did they have a New York Convention? And why did they update the protocol? The reason was not to make enforcement of awards more difficult, but to make it easier. And the same applies to arbitration agreements. And so it must be correct to say that it is open to contracting states to lay down more liberal requirements to those contained in Article 2.2. After all, the Convention just says each contracting state shall recognise an agreement in writing. It doesn't say shall not recognise an agreement in writing that doesn't conform to Article 2. It's designed to be pro-enforcement, not anti it. But as I said earlier, actually modern technology has taken much of the bite away from Article 2.2. There are very few arbitration agreements that are signed by the parties. Those that are clearly formally valid under almost any known legal system. But the real kicker is the exchange of letters or telegrams. Forget telegram, because that hasn't existed for an awfully long time. It was interpreted by the courts to mean telexes during the 1980s, but they've disappeared as well. In our modern day and age, we have email and we have text messages, both of which represent communication in writing. So if one party does a deal over the telephone and then confirms it by email, and the other side says, yes, absolutely, we have an exchange of letters as required by Article 2.2 of the Convention. Somewhat ironically, the rather stiff formalities of Article 2 have suddenly become the reality of modern commerce. And that explains why we get so many fewer disputes under Article 2. Beyond that, the ultimate question of Article 2 is, what does it apply to? We come back to the problem with Article 1, which lays down the scope of the Convention, but only for the recognition and enforcement of arbitration awards, not arbitration agreements. There are really two approaches that one finds. The UK approach historically has been to say, well, in the absence of a label, we will apply the New York Convention on Enforcing Arbitration Agreements to all international agreements. And there is then a definition of what is international, which is essentially something that isn't domestic. The Swiss approach is quite different. They, in a sense, read Article 1.1 into Article 2. Article 1.1 talks about the enforcement of arbitral awards rendered in a country other than where enforcement is sought. The Swiss read Article 1 over to mean that the Convention applies to the recognition of agreements that provide for arbitration in a country other than Switzerland. Both interpretations are perfectly respectable. Neither is technically accurate because, strictly speaking, there is no limitation contained anywhere in the Convention that relates to internationality or place of arbitration concerning Article 2. But at a later date, when somebody redrafts the Convention, the scope of application of Article 2 will be very high on someone's agenda. Article 2 has a reach a bit beyond its own terms because, as we'll see later, Article 4 and Article 5 both require the party seeking enforcement to be able to produce the agreement in writing described in Article 2.2. Beyond that, Article 2 really isn't very controversial. It simply stipulates that the arbitration agreement should be enforceable, otherwise no court will ever refer the agreement to arbitration. Some countries have chosen to expand Article 2 to say that the courts will only consider whether there is arguably a binding arbitration agreement before they send the case off to arbitration. That's notably the case with France. In fact, if the arbitration has already commenced in France, the courts will simply send the case straight off to the arbitrators without even considering whether there is a possibility that there is no arbitration agreement.